Well, thank you for all attending a very important salon we have this evening. My name is Bruce Fine. I'm the Vice Chairman of the Committee for the Republic, and I have the privilege to introduce our star speaker, Michael Luttig, former U.S. Court of Appeals judge for the Fourth Circuit, as well as having many, many other accolades, in his career. The battle hymn of the American Revolution was "The rule of law is king. The king is not law." General George Washington reinforced the battle hymn when he refused a crown in favor of a republic. On October 20th, 1973, otherwise known as the Saturday Night Massacre, I vividly recall watching CBS News in the evening. Robert Pierpoint appeared, breathless, on the White House lawn. President Richard Nixon has fired Special Prosecutor Archibald Cox to obstruct the investigation of Watergate crimes. Attorney General Elliot Richardson had resigned. Deputy Attorney General William Ruckelshaus had resigned. The FBI had sealed off the office of the special prosecutor, so it could not be accessed by any of the lawyers. I thought, the burning of the Reichstag has come to America. The next week, I was then serving in the Office of Legal Counsel. Would have been advising Mr. Luttig if he was then the Assistant Attorney General. The U.S. Department of Justice. I was summoned by then Acting Attorney General Robert Bork to his corner office, and he tasked me to investigate what were impeachable offenses for presidents, so-called high crimes and misdemeanors. That issue had fallen into dormancy for 100 years since Andrew Johnson was impeached and acquitted in 1868. Meanwhile, 2 million Americans discharged their duties as citizens and sent telegrams to the White House protesting Mr. Cox's firing, insisting that he be either reinstated or a new special prosecutor appointed. Remember, telegrams at that time were more onerous than an email. Took some affirmative effort. I devoted almost 18 months to impeachment, factual and legal issues, until President Nixon resigned under impeachment cloud on August 8th, 1974. I remember that date as one of the Constitution's finest hours. My heart leapt up when I saw Mr. Nixon leave the White House lawn in that helicopter. He was still under a criminal cloud, investigated by successor to Mr. Cox, Leon Jaworski, for obstruction of justice and other Watergate-related crimes. That was shipwrecked by, I think, President Gerald Ford's ill-conceived pardon. But Mr. Nixon had to accept the pardon, which accepted that he was indeed guilty of these crimes. But what August 8th, 1974 stands for was, at least at that moment, the rule of law prevailed, the line held. We are now approaching the 50th anniversary of Watergate and President Nixon's resignation, and the national bow to constitutional government. But the citizenry and office holders today are not made of the same stuff they were made of in 1974. Constitutional illiteracy is epidemic. Everything is based upon who wins. There are virtually no principles that don't succumb to ulterior motives. This may be captured in a comment a member of Congress made to me while sitting in the Capitol Hill Club. He said, "Bruce, talking to my colleagues about the Constitution is like speaking Shakespeare to cows." Right? They don't get it, and they don't care. January 6th represented the first serious challenge to the peaceful transfer of presidential power in the history of the United States. It stands in a class by itself. It's what lawyers call sui generis. It is up to us to make sure it remains sui generis. That's our duty as citizens. And we dare not fail to try and display ingratitude to those who have risked that last full measure of devotion for the Constitution. Our speaker tonight, Judge Mike Luttig, needs no introduction from me. He is a luminary in the legal world like Michael Jordan was in the world of basketball. And I say this with utter respect and humility that words would only cheapen the glitter that attends Mr. Luttig. He is above party. He is a man of principle. He is a man of enormous talent, writing, speaking, and otherwise. And if this country is to be rescued from the peril of oblivion and destruction of the rule of law, it'll be because of persons like Judge Luttig. So now I'm going to turn the podium or the speaker, the response to Judge Luttig, and the first question I'd like him to address, and he can add whatever he wishes. What do you think about the U.S. Supreme Court's decision overruling the Colorado Supreme Court's disqualification of Mr. Trump based upon Colorado law from the Colorado presidential ballot? And then we'll take it from there.
Thank you so much, Bruce. Really very much appreciate it. I'm here tonight because I would have never missed the opportunity to listen to Bruce Fine. I don't know why the rest of you are here. And I'm only half kidding in that. Well, let's just dive right in. So, as all of you know, the Supreme Court unanimously overruled the majestic, unassailable constitutional opinion of the Colorado Supreme Court. That decision was flawless. Our United States Supreme Court could have never even hoped to write a better opinion. But of course, it didn't try. It was clear during the 2 hours of argument, and I listened to every single word of it, that the Supreme Court only knew one thing when it walked in that courtroom that day, and that is that it was never going to decide whether Donald Trump was disqualified from the presidency. Not then, not now, not ever. It was the most astonishing oral argument I've ever heard in the Supreme Court in this way. The court as a whole barely asked, and it certainly didn't probe at all, one single one of the momentous constitutional questions that were at issue. Not one. In fact, most notable to me and to the public, but especially to me because it was one of my law clerks who was arguing the case, Jonathan Mitchell. Repeatedly, the court, various justices, would ask a leading question of Jonathan. Like, Mr. Mitchell, it seems to me that, you know, if you think about this provision of the Constitution and this provision of the Constitution and how they interface around this issue, your client should prevail. Listen to what I'm saying next. Every single time, my law clerk, representing the former president, said to the court something to the effect of, well, Your Honor, with all respect, actually that's not the case. The intersection of this provision and that provision and the wording of this provision actually cuts against my client. Think about that. And then listen to this. In the sort of the crescendo of the argument, two justices asked my law clerk, Mr. Mitchell, we're mystified that in this entire argument you've never even mentioned what the court believes is your primary argument, namely that the president is not an officer of the United States within the meaning of Section 3 of the 14th Amendment. To which my clerk responded to the court, Your Honor, the reason we haven't mentioned that argument is because it's a very difficult argument for my client to make to this court. Crystal clear. Well, you know, I can't say this publicly, but this is the press club. Am I supposed to assume everything's public? It was crystal clear, at least from the questions asked. That's my caveat of defense. That the court didn't understand the constitutional questions that were being presented. Did they really? We have to assume they did, right? Until we read their opinion. So, in arguably the most important constitutional and political case in our history, the most important case possible for a moment, and this moment in particular, this is what we got from the Supreme Court. We got a per curiam, a nameless opinion that no justice would put his or her name on, for which they can be forgiven. I wouldn't put my name on that, but they didn't. Per curiam. Well, okay, so it was a big deal. They wanted to speak as one voice. Well, they didn't. They spoke with one voice on one single result. For all you non-lawyers in the room, what that means to us lawyers in the room is that no one agreed on anything at all under the Constitution of the United States of America, except that they were not going to disqualify the former president from the presidency. You can take that to the bank as a description, but I'm going to tease it out so you have it, all right? So the court said in the result only that the states have no power to disqualify a candidate for the presidency of the United States. Well, in fairness to them, that's what they had said at oral argument. But it's just not true. There is literally, until last week, no support at all of any kind from anywhere for the holding of the court that states can't disqualify a presidential candidate, whereas they can disqualify any state officer for an insurrection against the Constitution of the United States. But, you know, this is technical stuff, but literally the only thing they held was that the states can't disqualify a presidential candidate. The holding hives off the other federal offices that can be that are disqualifiable by the definition of the holding of a court. So how did they reach that conclusion? Or what did they say? They didn't reach the conclusion under the Constitution. What did they say? Well, they would have been well advised to say nothing, frankly. But here's what they said. They said, well, you know, the 14th Amendment, the whole purpose of the 14th Amendment writ large was to restrict the states. So how could we possibly interpret the 14th Amendment to empower the states to disqualify a candidate for federal office? Now, that is a palpable misinterpretation of the 14th Amendment. It's betrayed by every single historian in that case through amicus briefs, but it's also, you know, the entire history of the 14th Amendment puts the lie to that argument. What I said before argument is that, well, yes, of course Section 3 restricts the states. It restricts them from sending back to office insurrectionists against the Constitution of the United States. And by the way, that's exactly what they would have wanted to do. And that's why, you know, the Section 3 was written to the states. No, you can't do that. We won't let you do it. They weren't, the framers of Section 3 weren't saying, no, we don't want you to do that for state offices. Although they did say that. They were probably not probably, they were most concerned about the states returning to federal office insurrectionists against the United States of America. That's what the court said. For that result, not even the reasoning of that result, the case was 5-4. There were 3 justices who quote, concurred, which all but makes the term a misnomer, because they dissented. Sort of. No, they dissented clearly, but they didn't want to be seen as really dissenting because they wanted to be part of the 9, right? But among other things that the 3 said, and this is Justices Sotomayor, Kagan, and Jackson, they said there's no support whatsoever in the Constitution of the United States for the reasoning of the majority. For all you non-lawyers, that's a big deal. And it's a bigger deal because they were right. Okay? Then, damningly, damningly, the three said, the majority today, you know, has reached this result such that the former president will never be disqualified or even disqualifiable from the presidency. The majority, said the concurrence, today has decided that no person ever in the future will be disqualified from the presidency, even if that person has engaged in an insurrection or rebellion against the United States Constitution. 3 justices said that. The 4th justice wrote separately, Justice Amy Coney Barrett, to say 2 things, both notable, in a paragraph. One, there's no support at all for what the majority's done. But by the way, this is not a time for stridency, in the opinion of my concurring colleagues. Never mind that there was not one single word of stridency, not one. And I would know a word of stridency if I saw it, because I've never been hesitant to write stridently when the moment called for it. That's what she berated her colleagues for. What was she doing? She was just trying to protect the majority for, you know, doing what it had done, but at the cost of criticizing the concurrences for agreeing with her straight down the line? Come on, right? So in the moment when the nation needed the Supreme Court, when the Constitution of the United States needed the Supreme Court and the nation needed the Supreme Court, the Supreme Court of the United States betrayed both.
What other opinions, this may be the worst, but haven't there been other instances? Oh. Okay. 1, 2, 3, 4. Yeah? Oh, this is better. No, not better. It has a green light on it that says it's supposed to be. All right, here we go. We had a unanimous opinion as well in the first of the Japanese concentration camp cases, Hirabayashi. So some would say, well, it's 9-0. They can't all be wrong. But occasionally that does happen, especially when you have very politically polarizing issues.
Never before, to my knowledge in history, have they all said in the opinion that they were wrong. And I'm not being facetious about that. Yeah. As I described it, none of them agreed on the reasoning. They just agreed on the result.
Yeah.
You tell me if that happened in those cases.
No, not in Hirabayashi. Anyway, let me ask you this question. Now, one of the things I think most people think about is that because the presidential election is a nationwide election, even though it's state by state, it just seems intuitively anomalous to have some candidates on the ballot in some states but not in others. And it seemed to me that in the court's preoccupation with the 14th Amendment trying to suggest it was curtailing state power, really the power of the states over president elections is in Article 2, Section 1, which provides plenary state authority to decide how presidential electors will be elected. I know as late as 1857, South Carolina was still appointing presidential electors by the state legislature. They didn't even have popular votes. So why would the court ignore Article 2, Section 1, which anticipates the checkerboard type voting for president that the court seemed to suggest was just totally unthinkable?
Because it wouldn't enable them to get to the result they wanted.
Yeah.
And I don't say that lightly, but I will say it publicly. In this instance, there is no other explanation. So to the substance of it, yeah, Bruce, of course, is right. What the court said, just literally said, and this is as revealing as anything, it said, after it had wrought the damage that it had to the 14th Amendment, you know, I guess the court thought it would be embarrassing if they didn't at least address the electors clause and the elections clause, which together unquestionably empower the states to qualify and disqualify candidates for both state and federal office. So this is what the anonymous Supreme Court said about that, and only what it said. It would be odd or something. That's not a quote. It would be odd for us to read the electors and the elections clauses as impliedly giving the states the authority to disqualify federal officials. Silently. That's what the Supreme Court of the United States said in this per curiam anonymous opinion last week. I mean, let's just think about that. What are they even talking about? As to that, you know, since the founding and the ratification of the original Constitution, the electors clause and the elections clauses have given the states, as Bruce said, essentially plenary authority over every federal election, every aspect of federal election, every single aspect of it for almost 250 years. No one's ever said that the Constitution silently gave them that authority. That was it. No further explanation. But going back to the checkerboard, which follows from that question by Bruce, so Professor Tribe and I have just literally minutes before I came over here finished an article for The Atlantic on Anderson versus Trump. So what we say in that article is, you know, from the moment that anyone heard Justice Kagan, Elena Kagan, put the question to counsel for Colorado plaintiffs, that, well, gosh, Mr. Murray, it just seems to me that this seems peculiarly federal in nature. How could we possibly allow an individual state to disqualify a candidate for the presidency of the United States? And then think with me, each state could come to a different conclusion even, disqualifying the president and not disqualifying. And my God, that would be chaotic. How can we possibly read the Constitution of the United States to permit of that utter chaos? To which Jason Murray said, well, Your Honor, the whole point of this case is for you, the Supreme Court of the United States, to decide it. And when you do, that will be the uniform rule for the nation. There will never be a patchwork and chaos of the kind you're talking about. And then, as we say in this forthcoming Atlantic article, of course, there's no mention of that. Now, what I was telling Bruce, beforehand, the Chief Justice and I were very good friends. We and still are, and we interviewed literally hour to hour, back to back, with President Bush for the Supreme Court. And obviously, the president chose John. But I'm as certain of this as I could be of anything. The moment that John, the Chief Justice, heard Elena Kagan ask that question with the passion that she asked it in, he's a smart man. He said, I can get 9 votes around that. And whether he thought that in the moment, that's, of course, what happened. And that's how he brought the 3 so-called liberals even onto the result.
Yeah. Well, isn't it? It's true that there are many presidential candidates throughout history who have appeared on some state ballots and not all. Ralph Nader, Green Party candidates, probably Robert Kennedy Jr. this year. So Elena Kagan was getting anxious and fretting over something that's contemplated in routine in American politics. It happens all the time.
Contemplated and routine.
Yeah.
But the court asked this series of questions as if it knew nothing at all about the practical history that Bruce just talked about.
Yeah. It also seemed to me, and you pointed that out in your answer, that the court's saying, well, we'll end up with this checkerboard. Not if the Supreme Court decides the case. If the Supreme Court decided there was an insurrection, that's the end for all 50 states. It's uniform. It would be like the court, to me, saying in Brown against the board, well, some states might have segregated schools, some not, and so, we can't let the states decide whether, there needs to be desegregated schools. But the whole purpose of the court is to be the definitive decider as to what the Constitution means for all 50 states. So the only reason there'd be checkerboard, because you let it be a checkerboard and decided not to do your duty.
Right. So in this article, I'll try to remember the literature of this passage, but we said the court feared deciding that the former president is disqualified, or feared deciding whether the Republican nominee, presumptive Republican nominee for the presidency, is disqualified because he's the presumptive Republican nominee. That's my best thinking. And I can support it.
Yeah. Well, that's not the only time. It was even more disastrous. Remember the Dred Scott decision? Chief Justice Roger Brooke Taney said, now we've solved the slavery problem, in saying blacks had no rights that whites were required to honor.
Let me address that. So yeah. Of course that's right. Okay. But neither are the parallels, what you suggest. Because of what I really just said. The Supreme Court, it didn't do, well, it did what it thought Americans wanted as a political matter. And that's why, it's the proverbial one-day story, right? except for the damage that the court did to the Constitution in order to decide that political issue. But from the very beginning, right out of the box, when the court, after the court took the case, the national media and lots of other people started saying, well, look, this is the most anti-democratic thing that could possibly be done under the Constitution. To disqualify a candidate from the presidency? That the Constitution can't possibly mean that. And this hue and cry came up almost overnight, and to the point that I actually called, several friends in network television and said, look, I want to come on and address this. And I did. And I said, look, to your point, intuitively, yeah, this doesn't seem democratic. But actually, under the Constitution, it's the most pro-democracy provision. And what it says is disqualification is democratic. What's anti-democratic is the insurrection against the Constitution of the United States, for which you get disqualification. And now, that's if I heard a boo, you can boo all you want. I don't care. I'm talking about the Constitution. I'm not talking about politics. And those are the people who have criticized me. But if whoever wants to boo would like to talk about the Constitution, I'll be glad to.
But
I don't do politics.
Michael, I mean, it seems to me that the incongruity is even more pronounced when you think that the whole purpose of a Constitution is to say simple majorities don't always get their way. And that is, even if there was 100% that wanted to discriminate on the basis of race, you can't do it. And so to say, well, it would frustrate popular will, yeah, that's what constitutions do all the time. That's why we have a First Amendment, to frustrate popular will. So what else is new? We don't, and the framers said, well, we don't trust the popular will all the time. You can amend the Constitution, but that's what checks and balances are about. Just like we don't have popular sentiment decide whether E equals MC squared or whether the force of gravity is what Newton said. Sometimes they can get it wrong, and those who were drafting the Constitution, and it was ratified with state ratification conventions with popular vote, said, yeah, we need to have brakes on ourselves.
Yeah, and of course that's true, and I assume that the booers here and elsewhere, that, when the Supreme Court, through its interpretations of the Bill of Rights, its anti-democratic enforcement of the Bill of Rights, I doubt that the same booers would be booing, claiming that that's anti-democratic. Of course they wouldn't. It just betrays a fundamental misunderstanding, not of politics. It's a profound understanding of politics. It's a profound misunderstanding of the Constitution of the United States.
Yeah. But let me add this observation, Michael. You remember that Peter Finley Dunn, this was around the Insular case of the Spanish-American War, he said, well, whether the Constitution follows the flag, the Supreme Court follows the election returns. And he's writing about that around 1900. So is this another example of that wisdom? It's folk wisdom, if you will. Maybe it wasn't particularly the election returns, but they were a human weather vane trying to do something that they thought would be most compatible and would win at least compliments from the Washington Post and New York Times.
Yes, that, but not following the election returns. That's the nefarious point to be made. Mm. They weren't following the election returns. They were they ensured that the former president would never be disqualified.
Let's move on. One of the other cases that has yet been decided is Mr. Trump's claim he's absolutely immune from criminal prosecution for anything that he did during his years in the presidency, and where it was rejected in the lower courts. A simple statement, as I mentioned at the outset, the whole reason why we exist as a country is because the rule of law is king, the king is not law, and Mr. Trump is basically arguing the opposite. In the court, I believe it said April 25th for oral argument. So what is your assessment of, one, the court's decision to move in a fashion much slower than the Colorado case, and why is there a political element that you discern in the timing here that will make it very problematic to try to have any January 6th trial, assume it goes forward before the November balloting?
Yeah, let me answer it this way. Beginning with the result. It's exceedingly unlikely that as a result of the court's decision to hear the case, that the former president will be tried before the election. Everyone knows that. And the court knew it too. Now, on the specific timetable as we know it now, just so you know what backs up that point, the court, first off, it waited a month. We're talking days at issue while the court is deciding whether to take it. Days for whether there will be a trial. And the court knows that. Knowing that, it took a month to decide it. Then it sets argument for 2 months thence, April 25th, consuming 2 more months. And now all the commentators are, frantic, saying, well, look, the Supreme Court can decide this case in less than 10 days, and surely they will. I went on television and said, well, actually, this is kind of fun digression. Nicole Wallace had asked me to come to New York and into the studio, which is like the most fearful thing that I can even imagine in my whole life, but I had agreed to do it. So I'm sitting there on the set, maybe this doesn't scare you people, but it scares me out of my mind. I'm sitting there on national television with Nicole Wallace, and she begins to introduce me and what was to be a 40-minute interview on every issue possible. And I'm saying, I'll do this quickly, but this is so fun. And then all of a sudden, I'm just staring at her because she's told me, don't look at anybody else, nothing else. Never look to either side, never look behind me, don't look. It's just you and me, Judge. And I just said, okay. So I'm just staring at her, and I see her go, and then she just interrupts her sentence and says, ladies and gentlemen, we have breaking news. The Supreme Court has just agreed to hear the immunity case against the president. Judge, I hate to throw you this curveball, but what's your first reaction? And, unsettled, I said, well, I tried to get my composure by saying first, well, of course, Nicole, I'm just hearing this news right now. And then I said, look, there was no reason in the world for the court to take this case, none whatsoever. And that it has now taken it all but ensures the former president will not be tried before the election. And then afterwards, and now I'll just go real fast, I see 2 people on the floor, and I'm on national television, and then they start pulling my chair out of the set. So, like I told you, I'm going to just look at Nicole Wallace. No, if they take me out of the building, I'm still going to be looking at her, right? But they literally pull me away, and then finally I said, looking at Nicole, I said, what do you want? They said, go that way, go that way, right in front of the camera. And I said, that way? And they said, yes, go now. So I walked right in front of the camera to the door. And they came running after me and said, no, no, Judge, no, you're just moving you to the other side of the table. I said, well, then for God's sakes, just tell me that, don't tell me to leave. So I go back on, and we're on national television still, and then I continue talking to her, and they bring in 2 more chairs, not people, just 2 chairs. And then by the time I finished answering the next question, 2 more people joined me at the table, and 3 more joined me remotely. And the end of the story is I asked my wife, I said, what did that look like? And she said, absolutely seamless. Absolutely seamless. That's what they do. Though they asked me back after the show and told me everything, and I said, so do you do this every day? And they said, actually, Judge, this is very, very rare. So they jettisoned our 40 minutes, and we talked only about the immunity issue. Okay, so back to the substance. I apologize for that. We got to have some fun, don't we?
Yeah.
Bruce and I had the privilege of working in the Office of Legal Counsel, and whose job it is to think about, write about, and decide these kind of issues. There's never been an argument in this world that a former president is immune from prosecution for crimes committed while in office. None. Period. So some of my colleagues and I actually briefed that issue in the district court. Well, the district court is a district court. She didn't want to. She probably scared out of her mind to decide any of this. So she didn't accept our brief. So we turned around and filed it in the D.C. Circuit, which of course did. And we made this argument and this argument only. A president's never immune from prosecution. But if you conclude differently, there's one thing that a president can never be immune from prosecution for, and that's for attempting to remain in office beyond his constitutionally prescribed 4-year term after he's been divested of his presidential powers by the American people, preventing his successor from assuming the powers of the presidency to which he or she is entitled, and preventing the peaceful transfer of power for the first time in American history. Now, again, for anyone non-lawyer, that is the narrowest possible thing that could ever be said. But that's what the Supreme Court is supposed to be deciding, is the narrowest question. So we filed that same brief in the Supreme Court. The Supreme Court took the case. What are they thinking? Well, we know one thing. They assume that the former president will not be tried before the election. Are they thinking that they might reverse the D.C. Circuit? After the 14th Amendment case, I'm tempted to say, yeah, they probably will. But trying to keep my wits about me, there's no way in the world that they could reverse the D.C. Circuit Court of Appeals, except one. And I've never said this publicly. So don't repeat it. The same week, I believe, the court's going to hear a case called Fisher against United States. Fisher's a case of one of the rioters on January 6th, and who was prosecuted and convicted, and he claims that under the obstruction of an official proceeding statute for which he was convicted, that the January 6th riot doesn't satisfy the elements of that crime. So the way the statute reads is something like this. It shall be unlawful to obstruct an official proceeding by manipulation of documents, manipulation of evidence, forgery of the same, obstruction of documents, okay? And then the statute says, or otherwise obstruct an official proceeding. So, so my colleagues and I thought, we better file a brief on this one. So we did. And in essence, which I think you'll appreciate, we said, well, it would be a strange interpretation of a statute indeed if you were to interpret otherwise obstruct an official proceeding to be the synonym of the evidentiary obstruction when it's actually the antonym, which is kind of in English to say, look, they said you can't obstruct it this way or any other way, including by preventing the joint session of Congress from counting the electoral votes on January 6th. That is an argument that the Supreme Court that decided Anderson versus Trump might be tempted to accept in the immunity case.
But that wouldn't still dispose of the defrauding the United States theory.
That's correct.
Of a impartial presidential election.
I told you I didn't want to appear here with you. This guy knows far more than I do. Yeah. Okay, but Bruce is right. But it would. I think that Jack Smith would believe that such a holding would gut his prosecution, but it would not, negate it.
Let me ask you this, Michael. Why, after the January 6th committee recommended in its report that Mr. Trump be indicted under the insurrection prohibition in Title 18, that it was conspicuous that he omitted that charge in this January 6th indictment. Especially conspicuous because the sentence that is possible if you're convicted of insurrection is disqualification from holding office, the same as Section 3. So what do you think is going on? Why, since this is something that the January 6th committee came up with, including Liz Cheney, the two Republicans on the committee, do you think the Justice Department decided to, and do you think this was made by Jack Smith or by Merrick Garland or by Joe Biden not to have insurrection charged against Trump?
Well, let me answer that last softball. The President of the United States didn't have anything to do with this prosecution, let alone did Joe Biden tell him not to charge Trump with insurrection under 2383, okay? That was just, you were just helping me out. The Attorney General, of course, had a role to play in that, and there's nothing wrong with that. And then the obvious reason they didn't is only because not that the former president would have a valid First Amendment defense, but he could raise the specter of a First Amendment defense, that his words incited an insurrection. Now, totally frivolous claim. In fact, I first addressed this issue when I was on the court in a now famous case styled Paladin against Paladin Press against somebody. Paladin Press had written a murder manual, just instruction on how to murder someone. And someone had bought the book and murdered somebody. And the victims, the family of the victims, sued Paladin Press, claiming that they were liable in damages for it. And I wrote the opinion saying that yes, they were, because it was literally and only an instruction manual on how to murder somebody. You know, it wasn't one of these totally normal instruction manual on how to legitimately avoid tax. It was how to do this, and the Supreme Court denied cert on it. But in that point, in that case, I made, in the context of a real live case, the point that you just you can't say things that incite imminent lawlessness. That's axiomatic in the law, right? That's what I said before Jack Smith indicted Trump. I gave this to a lot of serious people, and I said, yeah, this is the answer. But it would have never, prevented Trump from just blowing the whole thing up, and I think now I would say that the Supreme Court would have been scared out of its mind to sustain a conviction for insurrection under Section 2383. But the point for us to all to understand is Jack Smith didn't have to charge him with insurrection. He could avoid the First Amendment, the aura of the First Amendment protection, by simply charging him with conduct that entailed no speech whatsoever. And that's what he did. So at the time, I thought that was brilliant of him, though I had decided that he could charge him with insurrection and get a conviction for it. But when he didn't, I instantly realized that that was a shrewd and the right decision. And then now that we're looking at these things unfold with immunity, it was beyond brilliant. So, yes.
Sure. Do you have one?
Yeah, I don't want to answer his questions. My God.
Good. Who wants to ask a question? There's a question.
What do you think about? What do you think about with the abortion case? They've thrown it out to the states, but in this case, they're saying it has to be federal. I regret that the fellow from Colorado said, "You have to decide that this is either true for all of the states." But why? I mean, I think people who are running as independents, they have to be get enough ballot signatures to be on the ballot, so they're not on all the ballots in the states. And why, if we can have the chaos of different abortion laws, why can't we have the chaos of different people on the ballot for the presidency?
That's exactly the right question to be asking the Supreme Court, because at the level at which they are supposed to be consistent, they're being inconsistent. And the only explanation is that they want a different result. actually, before Dobbs came to my mind, New York against Bruin came to my mind. That was the gun case, where the Supreme Court, for the first time held that there was a public right to carry, because there had never been a prohibition on the public right to carry originally. Okay. So take one step back. So I got a call one day from a number of longtime friends of mine from past Republican administrations, and they said, Judge, we would like for you to write an amicus brief in this case. And I said, well, I'm not really interested in the issue, and because of because of some crime that had come to my own family, I really didn't even want to think about the question. And they said, please do. And I said, okay. So I got in there and did all the research and thinking myself, and I ended up leading that amicus brief on Bruin, because there had never, ever been a right of public carry, not only since the founding of our nation, but ever before in history, going back to like the 1600s. We wrote that, and by the way, the other thing we said is to the court, listen, you cannot even craft a rule that would recognize any kind of public right that would not create absolute chaos in the country and for you, the Supreme Court. So what happened? The Supreme Court, it was just a dishonest historical description of the history of public carry in the United States and in the rest of the world. They just cherry-picked whatever they wanted to say, and that was not even convincing, and said there's an absolute right to public carry. They didn't even talk about any of the next cases that were obvious. For instance, well, you mean so you can carry a firearm on the streets of Manhattan? You can take firearms into the Super Bowl game. You can carry them into stores. You can carry in a restaurant. Nothing. Said nothing. And of course, in the 2 years since they've decided it, the states are pushing back, going, well, you decide this then. And right now the Supreme Court they don't have a clue what they're going to do. They should have thought of this before they decided Bruin. Dobbs, but the point that I want to make tonight as to Dobbs is this. The people who know my friend John Roberts on the court best, the three concurrences, they led their concurrence with John Roberts's now famous statement from Dobbs that if it's not necessary to decide a question, then it's necessary not to decide it. And they stuck that right in the face of the Chief Justice in the 14th Amendment case, where he was one of the five that decided as many as 5 momentous constitutional questions with the back of their hand that were never presented in the case and that were not necessary to decide the case that they decided. So that's an answer to your good question.
You got a question right here.
John,
John, oh, okay.
Oh, you got the microphone.
Yeah.
Okay. Give it over to
Sir, for those of us who understand autocracies, fascism, communism, all kinds of totalitarianism that we've lived under and survived, we realize what American democracy is. How do we get your expertise, your constitutional expertise, Bruce Fine's, Lawrence Tribe's, Janie Raskin's, how do we get it to the ordinary voting public, to the ordinary citizenry, to understand what is at stake, the very existence of that American dream and model?
Well, the place to have started was at the Supreme Court. If the Supreme Court is not going to do it, then there's really no one who can do what you're saying, right? I mean, and I mean this in all seriousness. I mean, just think about. I'm like a nobody, right? I tried to retire 4 years ago. I'm 70 years old. I haven't been in Washington for 20 years. I hate Washington. I hate everything about this place and everyone who's in this place. and it was only because there's not just a God but a devil that I got this call out of the blue on January 6, 2021. And in testament to it was the devil and not God, not one single person, public official in America for 4 years has even mentioned my name, to my knowledge. But I've got a pretty expansive knowledge of that point. Now, don't feel sorry for me, feel sorry for them, all right? Because we can probably stipulate that 80% of the public officials agree with every word that I'm saying. They're just cowards. Just absolute cowards. And so I know that I've got the support of, God, I mean, probably 90% of America, but I'd have the support of 0 Republican. And so, you know, I'll keep talking out, but it's speaking out, but it's irrelevant at this point. I can influence the decision makers, and presumably I've done that up to now, but now nothing I have to say matters. This is 100% pure politics. And the people who want Donald Trump, they don't really care what he's done or what he will do. They're going to vote for him. And if you can believe the polls, today, he would be the next president of the United States.
Thank you, Judge.
Yes.
I'm also a board member of this esteemed Committee for the Republic, and I've got a couple of questions for you. Isn't it a weakness of your argument that you define your conclusion, i.e., you assume a priori that Donald Trump committed insurrection on January 6th? Secondly, you seem to have conceded that Jack Smith didn't charge the former president under the Insurrection Act because he acknowledged that the former president has a First Amendment claim. And you're saying strategically that was a good decision. And thirdly, isn't it basically the holding of the Supreme Court in the Section 3 case is that it's up to the Congress to establish the procedures for determining who is an insurrectionist for purposes of disqualification. Mm-hmm.
All three,
I'd like to hear your
yeah, they're all
response.
Three interesting questions. First off, I was a philosophy major 100 years ago. That's where I first learned the phrase a priori. So if I'm sure of nothing else, I'm sure that I have not decided a priori that the former president engaged in an insurrection against the Constitution. Okay? I've never done that in my life. And I'm sorry you heard me say that. I determined under the Constitution of the United States and nothing else that the Constitution disqualifies him. And I've put every single word of that constitutional analysis in front of the American people. Not one single word of predisposition or of politics. Okay? Now, I did not say, in fact, I said the opposite. I did not say that Jack Smith, that the former president, had a valid First Amendment defense. I said just the opposite. He didn't. What I said was that if he had charged the former president under 2383, the former president would have had a political heyday with it. Not because he had a valid defense, but because it would allow him to go out and, you know, and rally by saying that Jack Smith's trying to deny me my First Amendment rights as a president of the United States. No one should have to put up with this. Okay, so those are your first two questions. Then the third.
He said only Congress. Congress could decide procedures for disqualification.
Yeah. That is a constitutional question of the highest order. And the Supreme Court of the United States, remember, as I said, decided that first, only Congress can decide who can be disqualified from the office of the president. Neither one of those holdings, one embedded in the other, is even arguably correct, as the four concurrences / dissents said when they said to the majority of 5, there is no support whatsoever for this holding. Now let me break that down for you. It's my responsibility. This is technical stuff. No reason in the world any of you should understand it. It is a totally legitimate question whether Section 3 is self-executing or whether it requires action by Congress. Section 1 of the 14th Amendment, that's the whole ticket of the 14th Amendment, if you will. That's what creates in all of us our fundamental rights as against the states. Okay? Now listen to this. Section 1 is self-executing. Never in the history of America since the ratification of the 14th Amendment has anyone suggested that Congress would have to act in order to enforce Section 1 rights, and that would be an abomination under the 14th Amendment. What did they do last week, the Supreme Court? They said, well, we think that Section 3 of the same 14th Amendment is not self-executing like Section 1. That's
the right result, isn't it?
No, sir. Are you listening? Right result?
Because
no right result?
Because you can't have every Secretary of State in the country deciding who can run for president, Judge. You know that.
No, the answer was obvious. The Supreme Court decides the Colorado case and decides whether or not the president is disqualified for the reasons and in the way that Colorado Supreme Court did. If they decided that he was properly disqualified, that's the rule for the nation. If they decided he was not disqualified in the way and in the manner and for the reasons that the Colorado Supreme Court said, then it's not the rule for Colorado, and it's not the rule nationwide. The whole point of my discussion today is that the Supreme Court didn't decide it.
I want to just add for the audience, there was a 5-day trial held by the judge, not Secretary of State in Colorado. Trump was represented. There were factual witnesses, evidence on, and the finding was made there was insurrection. That factual finding was sustained by the Colorado Supreme Court, and it was not disturbed by the U.S. Supreme Court. And I can guarantee it was not a trial before a Secretary of State.
Right.
Before a judge.
That's right. And sir, there are the 3 other qualifications in the Constitution for the presidency, as you know: age, natural-born, citizenship and residency. The Supreme Court has held that none of those are that they're all self-executing also. Just like the Supreme Court has held that Section 1 is self-executing. Until last week, this is the first that the Supreme Court has ever said is not self-executing.
And it's just part of the Civil War amendments. The 13th Amendment against slavery is self-executing.
Right. And the 15th Amendment.
And the right to vote without discrimination based upon race. No one ever suggested that after the 13th Amendment was ratified, slaves weren't emancipated unless Congress acted.
Right.
If the 9-0 vote.
She's got the microphone.
Sorry. First of all, Judge, thank you extremely much for this illuminating presentation, especially for a person like myself who has no legal background. I deal in other areas in foreign affairs. What I'd like to know is, where is this now taking us? I know and I respect it, that you don't do politics, and I'm not asking for a political statement. But just as the Dred Scott led the way to paving for, unfortunately, became the Civil War, and then we saw the outcomes, of course, of that, overturning the Dred Scott decision. Right now, we've just heard that Liz Cheney has said that there will be nothing to stop Mr. Trump, if he gets into the White House this time, from leaving the White House. And considering that the last time he had been encouraged by some parties, including former General Mike Flynn, to form martial law, where are we going with this? And do you have any thoughts on that, sir?
Yeah, I've got legal thoughts only.
That's it.
Yeah. But these are the thoughts to be had, and they're from the mouth of the former president himself. Okay. He's denied January 6th for almost 4 years now. He and his supporters have promised that if there's a need for another January 6th in January of 2024, then they're going to be prepared for that. And his supporters, supported by him today, as you hear, are out saying, literally and factually, that there needs to be a revolution in America. And those people who say that are prepared to participate in that revolution. Okay? So literally, that's all the facts. So that brings me and you first to the question, what happens if Donald Trump loses in 2024? Now, again, factually, some of the greatest thinkers, in the country are suggesting that there might be a civil war. Now, backtrack to before my testimony. Some of the greatest thinkers were saying that then, and when I testified in Congress, I wasn't about to say that because that would be irresponsible of me. But what I did say is, do we want even a figurative civil war to be our legacy to the nation? Okay? So back to today, again, many people are saying, most importantly, including some of his supporters, right? In fact, the day before I was on Nicole Wallace, she had interviewed some professional person with indisputable credentials who had gone out and literally interviewed on camera some of the former president's supporters, and maybe some of you saw this. I mean, it was hair-raising. I mean, I can just see right now one woman who said, we will have a revolution, and I will be glad to participate in it, and there will be blood. Okay? All fact. That's where our first concern should be. And if we get past that, then you can talk about, how the president leads the country.
Max, just go ring it around.
Thank you. If the 9-0 vote was a foregone conclusion, and if 90% of the people, if the will is going against all of this, and if people are self-censoring or being censored, what is the origin, what forces are behind this, as far hidden forces, invisible forces are behind all of this as far back as you can go?
Well, even as to the Supreme Court, as I'm going to say in this Atlantic article, but indisputably as to the rest of the players, if you will, for the past 4 years, is fear. Donald Trump.
It's him, there's no one behind.
No, he doesn't need anybody behind him, but let's just play this out for a moment. He would tell you it's fear, okay? We don't need him to tell us. Every person, every Republican who crosses him, he destroys their political career. Liz Cheney, Mitch McConnell, and on and on and on. Every single Republican who's spoken against him, he's destroyed their political lives to the person. In fact, 90% of those that he's destroyed are no longer in public office. They either decided, I don't have prayer. So,
Domination.
Yeah. Now, someone had mentioned the word autocratic. Okay, so Nicole Wallace wanted me to address that point. So it should be clear by now, I don't address anything unless I know what I'm talking about. So I went into the dictionary and looked up all of these politically laden terms that I don't ever use, because if I was going to use them, it was going to be right. So unless I'm misremembering, the definition, dictionary definition of an autocrat is simply someone who demands loyalty and fealty to his or her views, okay? I was going to say that on Nicole Wallace that night. So it's just a statement of fact that Donald Trump, demands and insists upon complete loyalty and fealty.
Are the Supreme Court justices?
Well, that's for you to decide, you know.
I would just compliment your remarks, Michael, with kind of a different angle.
Please do.
And that is, I think, in part what's going on is the court as well as the country, when we become an empire, you know, has kind of made the presidency into a god. And the limitless power that is endowed the president with, by one refusing to examine any of the war powers that are usurped from Congress, accepting the state secrets doctrine, which is a license to lie. It's a license for secret government and never knowing what the government is doing. We have no clue right now. Nobody in this room knows what the president decides and how he's going to use a drone to do a targeted killing. We'll never know. Maybe 100 years from now, we'll get archives, 100, 200, 300, who knows? How can you have government by the consent of the governed when you don't even know what the government is doing? But I think that the court, being very sensitive, hey, it's the President of the United States, he needs to have a mandate to do whatever he wants to do, because how can you run an empire unless you have a Julius Caesar, is a companion to the fear factor of Trump. And in some sense, it's frightening because it's not going to go away when Trump goes away. The Supreme Court continues to ratify and strengthen the presidency at the expense of Congress, and Congress loves it. They openly say, we don't want to vote on anything serious. We could be primaried. We might have to confront an opponent. I mean, isn't it better in China's Xi and Russia's Putin? You don't have to run against anyone else. I said, and you're taking an oath to uphold the Constitution of the United States?
So you know, it's very important to remind all of you right now, you know, both me and Bruce Fine, I mean, I just can't even overstate it. Our job at the Office of Legal Counsel was to aggrandize powers to the presidency. So even today, I'm not going to speak for Bruce, but I'm a big believer of presidential power. But it's not unlimited.
Yeah.
So, you know, that's why I've been able to speak out, because the world knows that about me. And I'm glad they do. And I'm proud of that. But that means when I say this goes too far, it goes too far.
I observed that the Office of Legal Counsel, I antedated Michael there, we had examined this issue of whether or not a president out of office could be criminally prosecuted, and concluded, yes, it could be. That's why Leon Jaworski was pursuing Richard Nixon after he had resigned in lieu of impeachment. And OLC wrote a memo that was reinforced in the Clinton administration saying, well, if you're an incumbent president, that's another issue. But if you're out of office, there's no such immunity. And so the idea that the Supreme Court would take such a long time, I thought this was put to rest in the Nixon, the Watergate, 50 years ago.
So that's the point I was trying to make. In other words, once the Supreme Court took the case, actually, I didn't get to make. Once it took it, it would be irresponsible of the court to take less than the 2 months to the end of the term to decide it, because it is a big deal. And I guarantee you, we don't want the Supreme Court to decide that case and write an opinion in 2 weeks like they did in the 14th Amendment case. So that's why I said just instinctively on Nicole Wallace, I said, look, the court's never going to decide this case until the last day of the term. Why? The last day of the term is only 2 months from now, from the argument. And, you know, there's, look, the Supreme Court of the United States can and it ought to be able to decide a momentous case of constitutional dimension within days, just like they did Bush versus Gore. They could even write up a publishable opinion, but they actually don't have to do that. They just have to throw something down on a piece of paper that actually makes sense and resolves the case. But we don't want them to do that now in the immunity case. But it doesn't matter whether we want them to or not. It would frighten me if they decide that case and issue their opinion before the last week of term, and it should frighten all of you too.
Well, Michael, we've run out of time.
Well, I just wanted to.
I'll stay forever.
Yeah.
Okay.
I just wanted
good.
to.
All right, we'll go.
I just wanted to point out that it's been published that 97% of the media are Democrats, and only about 3% or less are Republicans. So that means that the news, the media is spreading, is biased totally toward the Democratic side. So that what most people are thinking is being biased. How do you feel about that?
Well, by way of Catholic confession, you could have probably caught me on any day in the first 66 years of my life saying that.
Be quiet.
And you know, and for just for fun tonight, you can assume that that's what I'm thinking. I'm not thinking about that at all with respect to January 6th and every single event that we talked thereafter. I know for a fact that the media is doing nothing more than, and you do too, reporting what happened and reporting what, well, no, let me finish. Let me finish. Let me finish. Reporting what happened on January 6th and reporting what Donald Trump has said in those 3.5 years since. Reporting the arguments that Donald Trump is making to the courts of the United States, verbatim, and reporting the decision of the courts. Now, if you disagree with that, videos of what?
Of January 6th, Tucker Carlson published the entire video, but the media, mainstream media, did not. They published what was in their interest.
The media can't publish all the videos of that.
Yeah, well, Tucker Carlson was able to.
That was because the Speaker of the House only gave it to Tucker Carlson and didn't give it to anyone else. That was his choice. And although he said it belongs to the American people, I didn't know whether he then decided he was going to steal it and give it to Tucker Carlson. Anyway, Michael's been very generous with his time. Yeah. The audience, I applaud. Let's give him a big
Thank you.
Good for you.
Thank you.
Great job.
Thank you. Thanks, Bruce.